My name is Akiva Goldman. I'm an attorney with Goldman and Associates, and I read the most interesting thing, and I wanted to talk to you about it. People were talking about certain concepts, and somebody had written into one of our sites and asked about a layaway process for a divorce. That's really, really interesting because when you think of layaway, you think of, you're going to a store, you want to buy a chair, you don't exactly have the money, so you put a little money down and they lay it away and you get your money together and you get your product. Can you do that in a divorce? Well, I got to tell you, I think there are some issues associated with that. There's nothing wrong with parking money in your lawyer's trust account for use at a later time. So in that sense, if you had money right now and you're thinking maybe I'm going to get a divorce down the road, so I'm going to take a few $1,000s and give it to my attorney, so hold it in his trust account. If I need it, great. If not, not. There's nothing really wrong with doing that. But we have a lot of clients in other divisions in our firm who keep money on retainer for legal needs that are going to come up. But in a divorce, it's a little tricky. Number one, most people don't know that far in advance that they're going to get a divorce, so that kind of planning is practical. Number two, if you park money with a lawyer and then 6 months down the road decide to get divorced, it's a question in my mind whether or not that money that you parked away is in and of itself a marital asset. You can say, well, it's money for my divorce, so why should that be any different than it ever is when people get divorced? Well, the reason is because you park part of your money and half of her money with your lawyer for your divorce. So you can expect that she's going to want the same availability of assets for her divorce, and if not, the court may very well regard that as a marital asset. If you paid it for your divorce lawyer and he started the case immediately, that's a different story. But leaving money in a place so that later on it might be utilized for that, I can see where a court might find that that's actually a potential marital asset, which would mean only half of it would be usable. The other half would go back to your spouse. So it's an interesting concept. I think the idea of planning for a divorce to such a degree kind of is inconsistent with the policy of the state of Michigan to keep families together. People plan years for weddings. They tend not to plan that far in advance for divorces. It's a little different if you know it's coming and there's some other issues. It's certainly something worth discussing. If you have any questions about this, or you think you're in a situation and you want to know what the legalities of that are, give us a call and we'll be glad to help you out. If you found this helpful, please like, comment, and share.